And perhaps Mr. Salerno, you can give us basically a general background of what led up to the case. Moving into 2009, I believe it was, the Coyotes lost somewhere around $300 million and were never able to profit. What did they do to try to remedy their situation, and how did you get involved?
I'm sorry, Kellen.
What led up to the filing of the bankruptcy, and what exact issues were they trying to address?
The Coyotes moved to Phoenix from Winnipeg. They were the Winnipeg Jets. 1996, they were losing money in Winnipeg. If you can't make money in hockey in Canada, that should be something in and of itself that tells you about the team. But they came here in 1996, and it was part of the expansion into the Sun Belt. That was Gary Bettman's, the commissioner of the NHL, his pet project. He wanted to expand hockey into non-traditional hockey markets: Atlanta, Miami, LA, Phoenix. And they came here. They were owned ultimately by Steve Ellman, who is the gentleman that also was a really real estate developer out in the West Valley. Jerry Moyes is the owner of Swift Transportation, one of the larger trucking companies in the U.S. Jerry Moyes became involved because he lent money to Steve Ellman in order to help him with a number of his business ventures, not the least of which was the Coyotes. The Coyotes had a loss on an EBITDA basis. They had losses every year from the year they moved here, from 1996 up till present. So under at least 3 sets of owners and the NHL ownership, they have never made money on an EBITDA basis. And so when Jerry Moyes acquired the team in 2006, he acquired the team. I may be wrong on that. But he wound up, he took the team because Steve Ellman essentially said to him, I can't afford to pay you back. Here's the keys to the team. There was the splitting of the sheets between Ellman and Moyes on various real estate projects. Ellman got the real estate, Westgate, which is out in out in Glendale, and then Jerry Moyes, lucky guy, got the Phoenix Coyotes. He took the team. He then he had about $200 million worth of equity that he put into it, and on top of that, he put another $100 million between 2006 and 2009 to help them with EBITDA losses. Because I mean, the team, when you look at the economics of any sports team, the single largest expense that you have, of course, is payroll. And that's not something you can say, gee guys, attendance is down, so we'd like you all to take a little haircut on that, and let's go on and put on a good show for the fans. Anyone's watching the NBA discussions, you know that these things are a little bit touchy, shall we say. And so in any event, he put $100 million into it. After losing money repeatedly, they tried to sell the team, and they got engaged in a marketing effort to sell the team, and found that there was no one that would buy the team for anything in excess of just the debt, leaving the team in Phoenix. And so what wound up happening was they expanded their reach, they expanded their marketing, and they found Mr. Basili. I always say Basili, I don't know if Basili, the BlackBerry guy. He is a ardent hockey fan. He had at one time tried to buy the Penguins, right?
Right.
Penguins and the Thrashers.
And the
Thrashers. Yeah, he'd been around the block, but he just loves the game. And he showed up and said, I will pay you money, a lot of money, for that team, but I need to move the team because it's not making any money in Phoenix, and it's kind of hard to argue with him when you've got 13 years of nonstop EBITDA losses. It's kind of hard to argue the point. Long and the short of it is, the only offer we had that was of any consequence was Mr. Balsili's offer. Susan's firm was counsel. And we went into a bankruptcy specifically with the intent to get the bankruptcy court to approve it, because we were told by Gary Bettman and the NHL that we were precluded from talking with anyone that would sell the team that would talk about moving it. That you were not authorized to do that. We said, well, let's see, let's test that. And we in fact tested it. We put the team into bankruptcy at the time we filed it in May of 2009. Gary Bettman was literally on his way over to see Jerry Moyes, and in his hand he had two pieces of paper. The first piece of paper was a term sheet to sell the team to Jerry Reinsdorf. White Sox, right?
White Sox and Chicago Bulls.
Yeah, Chicago. No, we still, to this day, I do not know what that term sheet says. It's never been turned over to us. My guess is it wasn't going to put a lot of money in anyone's pocket because Mr. Reinsdorf has come in and out of this deal numerous times since then and has never really made a final offer. The second piece of paper that he had in his hand was a piece of paper that was essentially taking away ownership of the Coyotes from Mr. Moyes. Under some financing, the NHL, when Jerry Moyes threw up his hands and said, I'm not putting any more money into this team, the NHL said, fine, we'll finance the team, the ongoing operations. As part of that, there was this piece of paper that he signed, and supposedly it gave over control of the team to the NHL at their option, so to speak. And so the other piece of paper that was in his hands that we do know about was a piece of paper that said, if you don't sign this piece of paper that essentially gives over the team to Mr. Reinsdorf, we are going to we're taking over the team and we'll sell it to him. And so, as he was on his way, we put the case into bankruptcy, and therein began a 6-month whirlwind of craziness that was very stressful, but at the same time very, very exciting, very exhilarating, and I think it's safe to say it was a case. And even to this day, given the latest developments in the Dodgers, probably the only case where there's really been, to a conclusion, the power of a league and the power of an owner that's come all the way to judicial decision. So it was a very exciting case to be involved in, and it's kind of the background.
Yeah, it seems like what actually ended up bringing to the court and to Judge Baum, and before Judge Baum makes any comments, as the presiding judge, he's not allowed to make any comments on the pending litigation, so just a minor disclaimer. It seemed that what was at issue was whether or not there was a good faith basis for the league ultimately making interference, if I'm not mistaken, and whether or not any interference was arbitrary, capricious. Can maybe you guys expand on the issues that the court faced?
Well, I think the issue is a little bit different in this context. All of these sports leagues have kind of about 4 fundamental contractual covenants in their documents. One is who can be an owner. So if you own the Coyotes, you're just not free to sell them to anybody you want for any price you want. You've got to get both your deal and your new buyer approved. And your contracts also say, in the context of the Coyotes, you're committed to playing your home games in Glendale, Arizona. You're not free to just, well, I think maybe a game in Los Angeles would be good. I can make a lot of money over there one night. You can't do that without the consent of the league and the other teams. So you've got this geographic covenant. You've got this, what I call the who covenant. If you want to relocate, you're not free to just pack up and move. There's some funny histories about this that precipitated it. One of them was the then Baltimore Colts in 1984. Indianapolis convinced them to move to Indianapolis. And the moving company was in Indianapolis, and the company's owner was a very good friend of the mayor of Indianapolis. And part of the deal was that the moving company would go into Baltimore at midnight and have them on the road and out of Baltimore within about an hour, which they did. But in today's world, there are very strict provisions and requirements that you've got to go through if you want to move the Arizona Diamondbacks or the Phoenix Coyotes or the Arizona Cardinals. You've got to go through all these procedures to do that. And then the other thing is you commit to pay for the operating costs of your team. Because for a league to function, the Tampa Bay Devil Rays need to know that the Coyotes are going to show up next Wednesday when they're supposed to play. That they're not going, well, wait a minute, we don't have money for plane fare, the plane's not going, we can't be there. And so there are very strict covenants on that. And what was at the heart, I think, Susan may want to chime in on this or correct me if she thinks I'm wrong, I think the real fight in the Coyotes case was really the who and the where. Mr. Balsillie had kind of done 2 dances with the NHL. He'd actually been, I think, approved is an owner of the Predators. He had been announced as a Predator at a Predators game in Pittsburgh. Here's the new owner, Mr. Balsillie. Deal never closed. And then in the Coyotes, the second thing besides the who was the where. He didn't want to buy the team and operate it in Glendale, Arizona. His deal was to buy the team and relocate it and have it play in Hamilton, Ontario, Canada. And I don't remember when Major League Baseball, the NFL, and the NBA showed up with a lawyer, but they showed up with a lawyer kind of had that figure to say, now Judge, you know they can't do this.
You know, there's an important decision that has a real impact here, and that's a decision that came out of the Ninth Circuit Court of Appeals, which is binding out here, of course, and it concerns the Oakland Raiders, when the Raiders wanted to move from Oakland to Los Angeles. And the NFL uniformly shot them down and said, no, you can't move here. We don't want you. And the question was whether there was an antitrust violation. The Constitution of the NFL at the time said that you can't come into someone else's home territory, you each have a home territory and you can veto anybody else coming into your space. The Ninth Circuit ultimately held that that was in fact an antitrust violation, that you should be able to move. And as you know, there are multiple sports teams. You know, even in New York, you've got 3 different NHL teams, and they all play, and they all make money, and it all works out. One of the things that the Ninth Circuit said in that case was that you can't just have a unilateral veto. You have to have criteria that can be measured and evaluated to determine whether or not someone can in fact move. And so one of the things that we said going into the bankruptcy court is that you have this bundle of rights and obligations, and one of the obligations is to play in Phoenix, but one of the rights you have is to move if you meet the criteria. So one of the things that we showed in our evidence was that we did meet the criteria in spades to transfer the ownership to Mr. Balsillie and to move the team up to Ontario, where it would actually make money for a change and would be a benefit to the entire league. There were issues with respect to the fact that in the constitution of the NHL, it still had a unilateral veto. And the Maple Leafs said that they were exercising that in actually a dandy little letter that came out during the course of discovery after extensive efforts to block that discovery, but a letter from their counsel that says, we will exercise our rights for blocking anybody else from coming into this territory. But the bottom line is, in a bankruptcy case, you can force a sale. You can force a transfer of ownership, and you can force kind of compliance with a contract. One of the things that you don't have in negotiations outside of bankruptcy is that ready access to a judge, someone who can look at this and say, yes, you're meeting the criteria, or you're not meeting the criteria. And as Judge Baum ruled, every contract, and you all know this from first-year contracts, every contract has implied rights of good faith and fair dealing. You know, you can't just say, no, I don't like the color of your skin or your nose or anything else, and therefore I don't want you here. In bankruptcy, you can force an assumption and an assignment of a contract. You can force a sale of a bundle of rights, which include rights under contracts. If you can show that a defaults are cured, and there we get to questions of not illegal defaults, is the requirement that you play only in Phoenix and that you cannot move an illegal kind of a default. You can't, or immaterial defaults, you can ignore those. The fact that we applied to transfer after the deadline in their bylaws and criteria. And you can transfer when you have consent. And so there you get into questions if you have deemed consent because you have in fact complied with all the criteria, and you can show that, then you have deemed consent and you can force a move. One of the other provisions in the Bankruptcy Code is that you can force an ascension and an assignment of a contract and compliance with a contract if the party who's objecting, if the interests of the party who's objecting are in bona fide dispute. And Judge Baum ruled that there really was a bona fide dispute here over the rights of the NHL to block this sale to Mr. Vasily and to block the transfer. But all of the cases that deal with bona fide dispute cases in a bankruptcy really deal with, do you have the right to X dollars or Y dollars? Are you really a creditor or are you not? And those are things that can be taken care of afterwards when the dispute is finally determined. And then you get X dollars or Y dollars or no dollars. But Judge Baum, I think, correctly ruled that once you have moved a team, you can't unwind
now
that.
it's going to go to his head. You don't want to
Yeah.